Hi, I'm Badette and I will be discussing DENR Administrative Order number 2021-27. These guidelines on the issuance of provisional agreement for all tenure instruments issued under the forestry sector was issued last August 3, 2021. This was published and acknowledged by the Office of the National Administrative Register of the UP Law Center on August 23 and 24, 2021. Before the pandemic, we were able to monitor and visit our tenure holders in coordination with our field offices. One of the major concerns in terms of processing forest tenure applications is the on-time issuance of the NCIP clearance. As we know, based on existing guidelines, applications which have completed the assessment and evaluation are endorsed by the DENR regional offices to the National Commission on Indigenous Peoples for the issuance of the appropriate NCIP clearance. However, it was observed that there are delays in their response, which resulted in delayed project implementation and investments in forest lands. With this, the guidelines on the issuance of provisional agreement was formulated as a practical approach to maximize utilization of forest lands and propel market investments. The provisional agreement may be issued to all applications for new, renewal, and conversion of the following tenure instruments: Integrated Forest Management Agreement, Socialized Industrial Forest Management Agreement, Forest Land Grazing Management Agreement, Forest Land Grazing Lease Agreement for conversion to FLGMA, Forest Land Use Agreement, Forest Land Use Agreement for tourism purposes, Community-Based Forest Management Agreement, Other Lawful Purposes Lease Agreement for conversion to flag or flag T, Special Land Use Permits for conversion to flag or flag T, Tree Farm Lease Agreement, and Agroforestry Farm Lease Agreement for conversion to SIFMA. Before we proceed any further, let us first define what is a provisional agreement. DAO number 2021-27 defines a provisional agreement as a 2-year agreement granted by the state to a natural or juridical person who applied for new, renewal, and/or conversion of tenure instruments under the forestry sector, and which have been endorsed and received by the NCIP for the issuance of either Certification Precondition or Certificate of Non-Overlap. The DENR Regional Executive Director shall issue the provisional agreement after 15 days, reckoned from the date that the NCIP has received the endorsement of the tenure application. Now, let us go to specifics. For new applications, the holder may proceed with a ground survey, delineation, and demarcation of the boundaries of the would-be tenured area. The holder shall start activities to manage, maintain, and protect the area against any form of unlawful activities, and the company may be allowed to introduce temporary improvements in the area that are necessary for their operations. In case of renewal application, the holder shall not introduce additional permanent improvements. Instead, they shall continue management and protection activities against any form of unlawful activities. The holder shall follow the terms and conditions of the previous agreement, and they shall be authorized to harvest and utilize the products from existing agroforestry and established tree plantations in accordance with the approved management plan or permit. With this, they won't be held up in terms of utilization, which might affect market potentials. For conversion to other tenure instrument, the holder shall also not introduce additional permanent improvements, but they shall continue the management and protection activities and follow the terms and conditions of the previous agreement or permit. And in terms of fees, the government share shall be computed following the existing guidelines under which the tenure instrument shall be converted. Once the corresponding tenure instrument is issued by the DENR, the provisional agreement shall automatically be terminated. Otherwise, it may be extended if no CP or CNO is issued within 2 years, or until their application is finally approved, and provided that no violation of existing laws, rules, and regulations was incurred within the duration of the Provisional Agreement. For clarification, the validity period of the Provisional Agreement shall form part of the 25-year period of the tenure instrument in conformity with the 50-year limitation on the utilization, development, and conservation of natural resources under the 1987 Philippine Constitution. It is important to know the responsibilities of the Provisional Agreement holder and the DENR. For the holder, they shall strictly comply with the terms and conditions of the Provisional Agreement and earnestly secure the corresponding NCIP clearance within the 2-year period. The regional office shall assist the holder in securing the corresponding NCIP clearance by endorsing the tenure application to the concerned NCIP regional office consistent with existing laws, rules, and regulations. In case that a resolution of non-consent is issued by the indigenous cultural communities and the application is finally denied and returned by the NCIP regional director, the DENR regional office shall issue a notice to the applicant to vacate the area and dismantle all introduced temporary improvements within 7 days, while all permanent improvements shall be subjected to takeover by the government pursuant to existing laws, rules, and regulations. The provisional agreement shall be deemed terminated, and the area will again be available to be placed under appropriate management arrangement and/or may be open for investment. That's all for DAO number 2021-27. Thank you!